My name is Colin Parks, and I am the Senior Director for the TFAS Summer Law Fellowship, and it's a pleasure once again to have you all with us. This evening, we have the great honor to launch the Paul Windels III lecture series. We have had a lecture series as part of this program for some years now, but thanks to the immense generosity of Mrs. Kathy Windels, we are so honored to be able to rename this lecture series after someone whose life exemplifies the pursuit of principled, courageous leadership. And I can't be more thrilled to facilitate this lecture series, not just this summer, but hopefully many years to come. Before you, you'll see a list of our lectures in this series. Here, we will be launching the series with a discussion on the administrative state with Mr. Mark Chenoweth, but we'll also have discussions on due process and immigration, religious liberty, a call to make Congress great again, a survey of the cases decided in this latest term, last term of the Supreme Court, and then a pending discussion on what is originalism with TFAS board member Randy Barnett. But before we get underway with the first installment of this series, I would like to welcome up and introduce to you all our president, Roger Ream, to give a few remarks.
All right, thanks.
Thank you.
Thank you, Colin. Hello to all our law fellows. I'm sorry I missed you at the opening program out at Scalia Law. I was traveling that day. I know you met our chairman, Randy Teague, and my colleague, Steve Slattery, who's here. But all the reports I get are very positive, both about how great you guys are. Colin does a great job selecting law fellows, and also that the program's off to a good start. It's my honor to be up here to welcome you here tonight for this first lecture in the Paul Windels III Memorial Lecture Series. This lecture series honors an exceptional individual who I was pleased to have known. He's someone whose life embodied the kind of moral courage and integrity that we emphasize in all our TFAS programs. He was also an individual who had a deep commitment to the law and the principles on which our nation was founded. Paul Windels III followed the tradition of his grandfather and his father when he obtained his law degree, his being from Columbia University, and I know Rory here is a student at Columbia. Worth noting also is that Paul interned for Senator James Buckley, who we hold in high regard here, later Judge Buckley. No doubt that internship not only provided a network of lifelong friends to Paul, but also served to reinforce his commitment to integrity above all else, having worked for a man with such integrity. Just as important as this commitment to tradition within his family was in guiding his pursuit of a law career, is the fact that he had an ancestral connection to America's early history as a descendant of Governor William Bradford and the Pilgrims who set foot on this continent seeking religious liberty. That was not simply a point of genealogical interest to Paul. It was a living responsibility that informed his professional endeavors. In a very real sense, Paul viewed the law as a sacred trust, a continuation of the work begun by his ancestors. Those who had the privilege of knowing Paul recognized him as a man of unwavering principle and moral clarity. Robert Perry, a colleague of Paul's at Brown Wood when they graduated from Columbia, and later longtime co-partners at the firm of Perry Windels, wrote this following Paul's sudden and unexpected death. And I quote, "Paul was the best educated person whom I ever met. With wisdom he obtained not by not squandering his youthful school years, but instead spent in pursuit of his many interests in politics and history. I sat astonished," Perry continued, as he could answer with relish and in great detail any question I had about English kings, world wars, and the past few decades in American politics. Paul's love of history was legendary among his colleagues and friends, and not just about English kings and world wars, I should add, but also of the Civil War, American presidents, and much, much more. We are honored to have a small portion of Paul's library on display in our lobby downstairs. It reflects a bit of his interest in American history and American presidents. What we have is only a fraction of his well-worn library. In conversations with Paul, history literally came alive, I guess figuratively came alive. I recall a dinner Paul and his wife Kathy had for me up in Scarsdale. And in fact, their young children were there. Mary Catherine, who's here tonight and is attending another TFAS program, and her brother Paul. They were very young, and I know don't remember this, but we had dinner at the Garth Road Inn one evening, and at some point in the dinner conversation led me to mention that one of my ancestors was John Rogers, who was the first Protestant martyr, burned at the stake for heresy by Queen Mary. Paul proceeded to fill in all these details about John Rogers that I didn't know or couldn't recall, about the work. Paul probably thought it was important work that Rogers did with William Tyndale to translate the Bible, what became known as the Matthew Bible, from English to from Greek rather into English. It was very impressive. I was very impressed and actually probably embarrassed at my ignorance. Not that Paul was embarrassing me in any intentional way, but he had such a sharp and educated mind, and his smile was contagious. You can see it on the screen when his picture comes up, and noted in the photos in the program. Paul understood the law, and that without historical context, law was merely rules without any wisdom or understanding behind it. He knew the law was something to be discovered, not enacted. That's why this lecture series and his memory is so important, and why we are so very grateful to Paul's wife, Kathy, and her family for supporting it. The speakers in this series will offer insights to provide a historical perspective and applications that will illuminate the law. I should mention the Windels family is also supporting our three professors. You've had Judge Maggs already. You're in the midst of a course on law and economics with two others who are Paul Windels, the third professors in our program. And they've provided 8 Paul Windels fellowships for students this summer, which we're very grateful for. It really enables us to recruit the best and brightest to this program. So thank you to Kathy, daughter Mary Catherine, and to son Paul Jr. In a very real sense, this lecture series is, I think, a continuation of Paul's work. Our goal is to ensure that Paul's example of moral courage, his passion for constitutional principles, and historic understanding will continue to inspire new generations of legal minds. Tonight and throughout the summer, we will take part in a living engagement with these ideas that have shaped our nation's history. Each lecture in this series will challenge us to think deeply about the constitutional questions of our time, just as Paul challenged those around him throughout his career. Through each of you, our law fellows, and what you take from these lectures, Paul Windels III's legacy will live on, and the principles he championed in life will go forward through the careers of each of you. Now I would like to ask Paul's widow, Kathy, to please come forward and offer some remarks. Thank you. Please welcome Paul.
Good evening, and thank you for being here for the very first of these Paul Windels III lectures. Paul would have been thrilled, and he would have been in some disbelief at seeing people gathered here on such an occasion with his name on the screen. And he probably would have been annoyed with me for some of the photos that I selected. But I can't possibly improve on Roger's remarks, which were, really very beautiful, Roger. Thank you. And Paul would have appreciated them, and again, been in some surprise at hearing himself spoken of so highly. But he was very modest. But he was, as Roger said, he was a man of great learning, well-educated, not just because of fine schools he attended, but because he read constantly, he thought, and he also sought out a wide variety of people with whom he agreed, people with whom he didn't agree. And so that's another thing I would suggest to you as you go through your careers is seek challenging people, seek great role models. And Paul was very fortunate, not simply in Senator Buckley, but as Roger has mentioned, in his father, grandfather, of course, his ancestors, like William Bradford. If you have not read the Mayflower Compact, which William Bradford served as the key author of, please do go read it. It's one of those very first of that type of documents that you will find in history, founding self-government on a daunting occasion where, if you may recall, most of the people on the Mayflower were not Pilgrims. The Pilgrims were the minority. The others were people they had hired to get them across the Atlantic without being drowned and having the ship go down. And so these were people they had to persuade to sign the Mayflower Compact. So self-government is a hard task. It does require people of integrity. It requires people willing to listen to one another. And this is something I hope you will all keep in mind in your careers. I was also very glad, besides hearing Roger mention Paul's love of history and his commitment to principle, that he did have immediate examples in his father and his grandfather. The first two Paul Windelses, the reason he was Paul Windels III was that his grandfather, the first Paul Windels, was the son of an immigrant who died in an untimely way and left the first Paul Windels to drop out of high school and support the family as he could. And he then was able later on to go back to attend Columbia University as an undergraduate and then to attend Brooklyn Law School at night. And this resulted in a family loyalty to Brooklyn Law School that was exemplified by my father-in-law serving for 40 years on the board of that law school, and for most of those years as chairman of the board. He was very proud of that. So the grandfather, Paul Windels, went on to become the right-hand advisor and supporter of Fiorello LaGuardia, who appointed him as Corporation Counsel of New York City. And if you ever steel yourself to read the entire book, The Power Broker, look at the index and you will see he was one of the major sources. Very, very fascinating man whom I never got to meet. And then his son, Paul Windels Jr., my husband's father, had similar challenges in life in that he was a student at Princeton and found himself going to Europe in World War II, where he was an artillery spotter at the Battle of the Bulge, where his feet froze on one occasion. And this was treated by the medic giving him medical alcohol to drink, which I don't advise you try at home. And he woke up 24 hours later with thawed feet and no pain. So that was obviously, it worked in a sense. But he came back and having been an artillery spotter, having been appointed as a JAG at the end of the war, with many challenging cases to deal with, including some that were quite harrowing for him. He returned and went into Harvard Law School in the middle of the first semester, flourished, and ended up being appointed by President Eisenhower to head the SEC in New York City, in the New York region, during the Eisenhower administration. So there were some very interesting people in the family, full of all kinds of stories. But one thing that both my father-in-law and my husband loved to do was to make people laugh. You'll see in one of the pictures my husband making Justice Alito laugh. So I'm going to leave you with a combination of Paul Windels' stories here. One of my husband's favorite stories to tell, which came from his father, and it's inspired by the color green on all the literature, as you'll see. So my father-in-law was a young litigator, and this is before his SEC days, et cetera. He's first experiencing life in a courtroom. The opposing counsel rose to his feet and said, "Your Honor, I must request an adjournment, I have to consult with a brand-new witness I have discovered, Mr. Green. My father-in-law, indignant, rose to his feet, said, "Your Honor, this is outrageous. We have heard nothing of Mr. Green." "Mr. Windels, in chambers," said the judge. So they went to the chambers, and the judge said, and this will be valuable to all of you perhaps at some point, "Mr. Windels, I know you're new to this. When a lawyer says he needs to consult with Mr. Green, it means his client hasn't paid him." So I, as my husband would have done, try to leave you with a laugh. Thank you very much for this great.
Thank you. I'd now like to introduce our speaker this evening, Mr. Mark Chenoweth, who is President and Chief Legal Officer at the new Civil Liberties Alliance. We have a fellow this summer who is interning with NCLA. Victoria Kelly is here, I believe. Yeah, wonderful, good. So it's a real privilege to welcome Mr. Chenoweth and to launch this series with him. He has observed the administrative state, so named the lecture, quite up close over the years from several perches in all 4 branches of the federal government. He served as the first Chief of Staff to Congressman Mike Pompeo, as legal counsel to Commissioner Ann Northrup at the U.S. Consumer Product Safety Commission. He was an attorney advisor in the Office of Legal Policy at the U.S. Department of Justice. And he served as a law clerk to the Honorable Danny J. Boggs on the U.S. Court of Appeals for the 6th Circuit. He's also worked in private practice, beginning his legal career as a regulatory associate at Wilmer, Cutler, and Pickering. And after such service, he returned to his home state of Kansas to serve as in-house counsel for Koch Industries. Additionally, he spent several years as general counsel of the Washington Legal Foundation before launching the new Civil Liberties Alliance. He is a graduate of Yale College and the University of Chicago Law Schools, where he co-founded the Institute for Justice Clinic on Entrepreneurship and became a Tony Patino Fellow. Mr. Chenoweth, again, is well-suited to discuss the nature of the administrative state, efforts to curb the administrative state, but also, if you have been watching or reading the news lately, NCLA is engaged in very important work on the matter of tariffs, particularly the administration's use of emergency powers to initiate said tariffs, and Mr. Chenoweth will also have some remarks on that as well. So with that, I turn it to you. Thank you.
Thank you for that generous introduction, Colin, and thank you for the invitation. Roger, thank you as well. It's a particular honor to be launching this lecture since I did know Paul and Kathy, and I was telling Colin that I have very fond memories of attending an AEI dinner with you guys. Gosh, must be 15, 20 years ago now. I probably shouldn't date us. But I just remember Paul being a spectacular conversationalist. That's the thing that sticks out for me, at least, and delighted to hear more about him and share some memories tonight. Maybe my first order of business is to convince all of the TFAS Fellows that the administrative state is actually the most fascinating topic that we could be talking about right now. Because I know a lot of you are probably looking at your course catalog at your law school and you're thinking, administrative law, do I really have to take that? That sounds deadly dull. And what I would tell you is that today, and this wasn't necessarily true when I was in law school, maybe I shouldn't have taken administrative law, but it's definitely true today that the most important cutting-edge constitutional law cases at the U.S. Supreme Court are administrative law cases. And so if you care about the Constitution, if you care about where this country is headed, and care about staying within the boundaries that the Constitution, that our framers set for us, then you should care about administrative law, you should study administrative law, and you shouldn't assume that what you learn in law school about administrative law is accurate. But we can remedy that later. But it's still a good foundation to have. I learned my administrative law from Cass Sunstein, and when I got to the Consumer Product Safety Commission and saw how the administrative state works in practice, I said, that doesn't work. That's nothing like what I learned in law school. So, but it's still important to have that background and that training in some of the cases that unfortunately are still precedents. When we successfully overturned Chevron deference last summer at the U.S. Supreme Court, I got a message out of the blue from someone I hadn't heard from in 20 years who'd been in that administrative law class with Professor Sunstein and said, "I remember when we first learned about Chevron, you objected and said that's crazy." So, congratulations. So that was fun too, because I remember that too. But so let me. The administrative state is a vast topic, and we can't possibly cover all of it in the time that we have tonight. But what I can do is maybe talk about, in short scope, 7 different aspects of the administrative state that NCLA particularly finds to be egregious. We were founded by Philip Hamburger, who's a law professor at Columbia University Law School. He wrote a book in 2014 called "Is Administrative Law Unlawful?" It's about a 700-page book. He calls it a doorstop, or his tome. And I liken it to a rich dessert. I read several pages. I'm like, wow, that's really all I want tonight. I'm going to save a little bit but he's a legal historian. It is a dense, rich piece of magisterial legal scholarship, which you can tell because it's had tremendous influence at the Supreme Court in the last 10 years. And when he wrote the book, folks said, "Well, Philip, that's great that you wrote the book and all, but books don't usually change much. Like, what are you going to do about it?" And Philip was familiar with and had worked with the folks at the Beckett Fund. I think I saw there were a couple people here who are working at the Beckett Fund. Did I see that in your bios? Yeah. Okay. Great. So NCLA was actually founded at the Beckett Fund. You may not know that, but I spent my first 9 months as executive director at that time of NCLA in Beckett's offices. They were on New Hampshire Avenue at the time, in fact, and the reason that happened is that Philip was very familiar with the work that Beckett and some of the other public interest religious liberty groups had done to fight for religious liberty, and Philip's first fame is as a religious liberty scholar. And he asked the folks there, well, do you think that setting up an organization that would do what you do but would focus on the administrative state would make any sense? And they were extremely enthusiastic about that idea because Beckett's experience was it wasn't legislators, by and large, who were passing laws to restrict religious liberty. It was bureaucrats. It was unelected people who were doing things that would crack down on religious liberty. Because if you're an elected official and you do that, you're probably going to lose at the ballot box because religious folks can organize against you in any sort of a democracy to undo that. But it's the bureaucratic power that's a little bit harder to get at. And they said, look, if that's happening to religious liberty, Lord knows what's happening to all these other sort of constitutional liberties and rights that folks have. So absolutely, they would support that and be willing to sort of let us incubate at Beckett's offices for a few months since we could kind of find our footing, and they kicked us out of the nest when their summer clerks arrived, actually. So then we were on our own, but it's been a great coming up on 8 years now, and the 7 things that we work on. I'm going to give these to you because this is the order in which it's easiest for me to remember them, not because it's the order, not necessarily the order of importance, but you'll see why I use this order in a second. So the first one is the First Amendment, and there's lots of groups out there that work on the First Amendment, including religious liberty, but also free speech. There must be, gosh, Roger, 10 free speech groups out there doing on the right. It depends if you count fire on the right or not, but that are doing religious liberty, or free speech work. But there was a gap that we saw that folks aren't doing as much of, and that is when the government uses crackdowns on speech as a shortcut for regulation. And that is often done with a speech mandate or a speech ban. And so that's when NCLA will jump in. If we find out about speech bans or speech mandates, And we expanded that a little bit over the last few years because we found out during the Biden administration that the federal government was engaged in the largest massive censorship program in American history, cracking down on social media for anybody that was going against the administration's narrative on a whole bunch of topics, but chiefly COVID-19. If you were posting things, even true things, on social media about COVID-19. So, for example, if you said that the vaccine doesn't actually stop transmission of the virus, true fact, they would censor that. And we have lots of examples of this. And so, we decided to get involved in that because the truth matters, and the government is not supposed to be the arbiter of truth. That's not the government's job under the First Amendment. Falsity is not typically a basis to deny somebody First Amendment protection. And yet that's, the government had decided that misinformation, disinformation, and malinformation were justification to ignore the First Amendment and to allow the government to sort of crack down on speech. So we've been fighting against that in addition to speech bans and speech mandates. So you may wonder, what's a speech ban, what's a speech mandate? So an example of a speech ban, the Securities and Exchange Commission has a gag rule. If you settle a case, which 99% of people who are sued by the SEC settle, you then are forbidden from challenging any of the facts in your original complaint against you, even though you and the agency both know at the time that the settlement is reached that some of those things aren't true or were never proven. So that's the DOJ doesn't do this. There's maybe the CFTC, maybe CFPB, there might be a couple agencies that do it, but it's really very limited across the federal government, but that agency does it. And so we've been fighting against that. We have a case pending in the Ninth Circuit against the SEC right now to try to overturn the speech ban. Speech mandate could be things like a warning label, and sometimes those are okay depending on the contents of the label and so forth, but a lot of times that kind of thing is forbidden under the First Amendment. The second category that we're active in is I think of as our Article 2 cases. So these are cases where agencies are exceeding their statutory mandate. And maybe the best recent example we have, we won a case at the Supreme Court last year, in a case called Cargill v. Garland, where the Bureau of Alcohol, Tobacco, and Firearms had decided to ban bump stocks. The only problem is Congress had passed a law in 1986 that outlawed machine guns, but bump stocks hadn't been invented yet, and that statute didn't address bump stocks, and ATF just decided, well, yeah, sure it does. And so it created 500,000 felons overnight. It took us 5 years to get all the way to the Supreme Court to overturn that, but the Supreme Court ultimately agreed with us that ATF didn't have the power to create criminal law on its own, and that's the job for Congress. I hasten to add, we never took a position in that whole litigation on whether or not bump stocks are good or bad or should be outlawed or shouldn't be outlawed. There's lots of states that have outlawed them, including Florida. That's all fine, but ATF can't do it. That was the position that we took in the lawsuit. The third category, I should say that another thing that we do in that sort of category of cases is our non-delegation cases. And for those who don't know what non-delegation is, Article 1, Section 1 of the Constitution, basically the very first sentence of Article 1 says that the legislative power belongs to Congress. And that's all the legislative power. And so what that means is Congress can give some things to the executive branch. It can have the executive branch do findings. It can have the executive branch fill up some details, but it can't just give up legislative power to the executive branch. And sometimes we find that that's happening. And when we see that that's happening, we sue over it. And so Colin mentioned the tariffs case. One of the charges we have in the tariffs case, we say, look, the statute at issue does not actually, as a matter of fact, give any power to the president over tariffs. The word tariffs isn't mentioned at all in the statute. But if you were to interpret this statute to say that it does give the president power over tariffs, then we've got a major non-delegation problem. Because you know what else is in Article 1, Section 8? Congress has power over imposts and duties, i.e. tariffs. They can't delegate that away to the president. That has to be Congress that sets tariffs, not the president. So those non-delegation cases are something that we work on as well. And NOAA didn't like that very much. It wanted to have monitors on all the time, and they said, you know what we could do? We could just make the boats pay for the monitors, and then we'll have funding all the time. And so that's what they did. But the problem is that agencies don't have the power to just tax people or just come up with fees when Congress hasn't specified that. And so that was, these monitors have been on the boats for, 20 years or so. Our clients, no one else had complained about that. But when the agency turned around and tried to make them pay for it, by the way, about $750 a day for a monitor, which is more than the fishermen on the boat get paid. Okay, so we're talking about a serious expense. And these monitors, imagine that you're, that someone's riding alongside you while you're driving on the highway, a state trooper, like riding shotgun with you while you're on the highway. That's the equivalent of what's happening with these monitors. They're watching your every move. They're not, by the way, particularly expert seafaring folks a lot of times. There was a hilarious amicus brief submitted in the Loper Bright case from some folks talking about all of the different sort of dumb things that these monitors would do while they were on the boats, including filling their shoes oftentimes because they were landlubbers and not used to being on the ocean as much as was required for this job. Our clients would go 2 weeks at a time out to sea. They had a trawler that was a freezer trawler, so they could catch fresh fish, freeze it on the boat, and then just stay out for a long period of time. The reason that let me tell you one other funny sort of aspect of the story. So our client, so Relentless is the name of a boat. The Relentless, the Persistence, and after we won the case, they bought a third boat called the Prevail. And so we're pretty excited about that. But our client, Megan Lapp, she's the sort of the liaison, has a wonderful Rhode Island accent, very thick. And we did a video, a sort of case video about the Relentless case, and she was asking her lots of questions on the video and so forth. And because of her thick accent, whenever she would say the phrase "an at sea monitor," it sounded for all the world like a Nazi monitor, which I loved. So I tried to get her to say that as much as possible. It was pretty funny. But when you meet people like Megan and you learn stories like this, you start to realize that the administrative state is a menace, and it's really, it's hurting people every day in real ways, and particularly when these shortcuts are being taken that violate people's constitutional rights, that shouldn't be happening. And I know some folks will say, well, what about expertise? How can we run the country without all these administrative experts? Well, that's where I'm glad that I served at the Consumer Product Safety Commission, which is it's a relatively small agency, by the way. It with a few carve-outs like guns and cars. The CPSC regulates just about every consumer product. There's a few telecom things that FCC regulates and whatnot, but just about everything. If you go into your kitchen, like everything in there basically is regulated by the Consumer Product Safety Commission. Relatively small agency. It does recalls. That's where you're going to hear about them most frequently. And it's about the agency is about half scientists. There's a lot of expertise there. They've done some fantastic things over the years. They're the ones who came up with the requirement that hair dryer, and they talk about this incessantly, that hair dryers have to have that little interrupter on it so that if you drop it in your bathtub, you don't get electrocuted and die, right? So they've come up with some good things over the years. But there was something that happened while I was there that was an eye-opener for me. And Roger, I think I told this story at the Philadelphia Society, so you may have heard this one before, but about the pool drain cover. Yeah. So the Congress had passed something called the Virginia Graham Baker Pool and Spa Safety Act because James Baker's granddaughter died in a tragic sort of spa accident. And about once a year, somebody does die because of a pool drain cover. Either their hair or their jewelry gets trapped and they drown. Or sometimes someone will sit in such a way that they're covering the whole drain, and it can be a problem, or at least before this some of these reforms came about. And the agency was ordered by Congress to do something about it, and they came up with the idea of requiring 2 drains in every pool and spa in America. Well, okay, so 2 drains cuts the suction in half, and it is true that if you cut the suction in half, this wouldn't be a problem anymore. It's also an extremely expensive way to go about solving the problem, and the chances of people doing that on a retrofit basis where they don't have to is basically zilch. So you're not really going to solve the problem on a retroactive basis. You might solve it on a prospective basis at most. Well, when they put this out for public comment, a brilliant scientist came in and she explained to the commission that she had a $20 solution to this problem. And if you guys have seen a pool drain cover, you know they're about this big around, right? And they kind of look like a honeycomb pattern on top, typically. Well, she said, well, that doesn't make any sense. What we need is a drain cover, like take that off. My drain cover sits in that same hole, but my drain cover is this big around. And it doesn't have any suction on the top at all. The suction is only around the outside edge of the cover. And there are channels that go all the way to the center of the drain from the radiating from the outer edge down or into the center. Maybe that's the reverse. But anyway, and she explained that how this would work, and the suction would be the same, but it would be coming around the outside. There's no way of getting your hair or jewelry or anything caught. You could sit on it safely. Basically solved all the problems. And, I don't know about you, but if I owned a pool and someone said, hey, for $20 you can eliminate the chance of anybody dying in your, your pool, I mean, sign me up for that. Yeah, I'll swap out that cover, no problem. So the agency voted to say that, yes, that cover was a solution. And for reasons I never really have quite figured out, the consumer safety advocate community went nuts, and they said, no, that's not good, that's not right. And they managed to flip one of the Democrat commissioners at the agency. And this wasn't flipped on a science basis. This wasn't flipped on an expertise basis. This wasn't flipped on any basis other than sort of a power move by the consumer advocates that wanted to show who was boss, and they did. Unfortunately, this particular pool drain cover was not deemed to be a solution to the problem, and this wonderful thing that could have been created wasn't, and I blame regulators for that. And so when people talk to me about expertise and what we need from regulators, I scoff a little bit at that, because I've seen too many times when it's not the scientists who are making the decisions at the agency, it's those politician bureaucrats at the top of the agency who are making those decisions. And why should we defer to them? That doesn't make any sense to me at all. The fourth area that we're active in is the Fourth Amendment, so administrative searches and seizures. So you may think that the Fourth Amendment only applies to police, but that's not really true. It applies to administrative agencies as well. So we have a lawsuit pending at the U.S. Supreme Court right now against the IRS because our client had cryptocurrency, and the IRS decided that people with cryptocurrency don't pay their taxes, so we're just going to go over to Coinbase and we're just going to seize thousands and thousands of records. They wanted about 100,000 records. The magistrate judge said, no, we're only going to give you 14,000 records, but included our client's records, who had paid all of his taxes. And the way this is supposed to work is you're supposed to have something called a John Doe warrant. And so you could go to Coinbase and you can say, I'd like the names of your customers, basically, and they can turn that over. Then the IRS can go and look at their records and see, well, did you pay your taxes or didn't you? And if they say, you have cryptocurrency there, but you don't say you have any over here, then they could maybe go get some more information. But that's not what the agency did. And so we're suing for a Fourth Amendment violation, and we'll see probably before the end of the month whether we're filing our reply brief at the end of this week, and the Supreme Court should decide the cert question sometime later this month. So that's a good example of that. The fifth category is the Fifth Amendment due process. Most of our cases have a due process element to them. A lot of times that lack of due process happens in an adjudication at an administrative agency. And there was a huge decision last summer from the Supreme Court in a case called Jarkissi that decided two things. First, that you actually do, contrary to what had been the practice for the last 50 years, you do have a jury trial right in these administrative adjudications if your private liberty is being adjudicated. And importantly, and in response to something that we pointed out in our amicus brief, that can't happen in the administrative agency, which means you have the right to an Article III tribunal, a real federal court, if they're going after any of your private rights. And so I think that the shortcut of doing away with jury trial rights at the SEC and many of these other agencies is one of the things that allowed the administrative state to grow so rapidly and so out of control for the last half century or more. And reinstituting a requirement for jury trials is going to make a huge difference. We're very optimistic about the effect that is going to have. But there are still other problems in these administrative adjudications with lack of due process. So for example, if the agency knows you're innocent and it has evidence of your innocence, it doesn't have to turn that over to you. Seems like a problem. It's not true in federal criminal law. There's something called the Brady Rule. If the DOJ is going after you and they have evidence of your innocence, they have to turn that over. And it doesn't have to be conclusive evidence of your innocence either. It's if they have evidence that tends to support your claim of innocence, then they have to turn that over to you. But we don't have that rule in administrative law, so they can just railroad you, even though they know that they have evidence that shows that. And you might think, well, does that really happen? Yes, we have a client that this happened to, and I don't have time to tell you the whole story, but I'm happy to tell anybody about it later. Just remind me about PHMSA, and which is the Pipeline Hazardous Management and Safety Administration, I think, but don't quote me on that. So the sixth category is guidance abuse, and it's a tricky one, because what happens with guidance is that a lot of times the courts will say, well, we can't adjudicate the guidance that the agency has put out because it's not final agency action. And that's a problem, because I'll just give you the example of what happened during COVID. We couldn't sue the CDC during COVID over its completely unscientific advice. And when I say completely unscientific, what do I mean? Well, for example, the agency was claiming for a while that the vaccine would stop transmission, and it wouldn't. It claimed that there was no such thing as natural immunity, meaning every other disease, measles, whatever, if you get the disease, right after you've recovered from it, you have immunity for some period of time, not forever, but for some period of time, you've got the built-up antibodies. The same thing is true of COVID. If you just recovered from COVID, you do not need the vaccine. Doesn't mean you never need the vaccine. You might, in a year or two, it might make sense to sort of raise your antibody levels, but you don't need it right away. Well, that's not what the CDC said. So, but we couldn't sue the agency because this was just guidance, right? This isn't final agency action. Well, but then we tried to sue Michigan State University because they fired our client for refusing a COVID shot. By the way, our client was a remote worker who only ever came to campus for her COVID test. So, go figure that out. And we lost that case because the district judge said, perfectly rational for Michigan State to follow the guidance that the agency put out, which, by the way, they didn't really follow the guidance because, for example, the U.S. government never approved the Chinese vaccine, but there were a lot of Chinese students at Michigan State who had only ever had the Chinese vaccine, and they said that was fine. But so they were picking and choosing a lot more than the judge was willing to recognize. But that gives you a sense for the kind of catch-22 that you might have with guidance sometimes. And then the last area that we're active in is conditions on spending. And this is actually thanks to James Buckley, believe it or not. When I was telling Kathy that Jim was on our original board of advisors for a few years before he completely retired from public life, and insisted that this be one of the things that, and frankly, it didn't take very much persuading because Philip was aware of the problem but just hadn't thought enough about it to sort of get us where we needed to be. Now we have. And so what is conditions on spending? The easiest way to describe it is, imagine Congress has given money to an agency to distribute. And maybe with some strings attached, maybe not, but they've given money to an agency. And then that agency turns around and attaches a bunch of strings to it and says, well, you only get the money if you do these 15 things. Well, Congress never said that. The agency is saying that. So that's legislating outside of the accepted constitutional way of legislating, which is bicameralism and presentment. This is just an agency coming up with additional non-statutory requirements before you get the money. That's not allowed. Happens all the time. So we're suing over that. A good example is the CHIPS Act, which gave money to the Department of Commerce to try to set up domestic microchip manufacturing facilities. One of the Department of Commerce requirements to get the CHIPS money is that you include a child care daycare center in your factory or on your factory grounds. Well, that's not in the statute. That's just something that the Department of Commerce came up with. Not sure what they know about daycare centers, but that's how those sorts of things happen. So that'll give you a sense. That's not all of the pathologies with with the administrative state, but hopefully that'll give you a sense of some of the kinds of things that we've been fighting against, and I'm happy to open up to questions that folks have and go into greater detail on some of these things, but I wanted to make sure we cover sort of the waterfront of what's wrong with the modern American administrative state. And Victoria's learning all about this summer. Yeah.
Mention, where you're from.
My name's Tyler Rosinski. I'm from New Jersey. I work at AAF, so we're doing a lot of amici briefs with you guys on,
Fantastic.
on the terrace right now, and they've been having me read your brief.
Yeah. This is Mike Pence's group, right?
Yeah.
Yeah, so you, in fact, I mean, they know this. I don't know if they've told you this. They're winning our Best Amicus Brief award tomorrow night.
Tomorrow night, right?
Yeah. They wrote a fantastic amicus
They're
brief.
very excited,
Yeah.
Mr. Wheat and them. I suppose...
Which, by the way, there were hundreds of amicus briefs written at least, maybe not hundreds, probably 100 though. Certainly dozens that were written just in the Loper Bright case alone.
When I started last week, they said, well, we're about to win an award because of what one of our interns last summer did. So, you
That's right.
worked pretty hard this summer.
That's right, setting the bar.
I was wondering, a question I have is, especially as I do not only reading your briefs and then the briefs we're submitting alongside you in these cases, what do you think is the relationship between the major questions doctrine and the non-delegation doctrine, which your group and our group are both working together to try to revive? One of the things they have me working on right now is Mayfield, which I don't know if NCLA is doing it.
We're not.
But certain things just aren't coverable under non-delegation, or under major questions, but you would think would be covered under non-delegation. So I just wanted to see, what do you think the relationship between those two doctrines are? Is one just a way to get back to non-delegation, or do you think they both have kind of independent lives? But just very related. Sorry, I know that's a long question.
No. It's a great question. It's something that a lot of folks have been thinking about, and we won't really know the answer until there's a few more Supreme Court cases in this area. But I'll give you my best guess. And for those who aren't familiar with the major questions doctrine, there was a series of cases from the Supreme Court over the last 25 years, or a little bit longer than that. But most recently, in the case West Virginia v. EPA, that's where they gave it the fancy name of major questions doctrine. And essentially what it says is that if an agency is tackling a major question, if the regulation that it's doing sort of implicates major question, then they're not going to assume lightly that Congress gave that power to the agency. They're going to sort of a clear statement principle. They're going to look for a more robust delegation or a clearer delegation in the statutory language before they agree that the agency has that power. And we're sort of the major questions doctrine is sort of a mixed blessing, because on the one hand, absolutely, if Congress hasn't spoken, that's a great sort of shortcut way to say, yeah, agency, you are out of line here. And a good example of this is what President Biden did with student loan debt forgiveness. There was just the statutory authority was not there to do basically anything that he did, but he was doing it anyway. And the Supreme Court, in a subsequent to West Virginia v. EPA decision, said that major questions doctrine, we need a clearer suggestion that from this. The problem is, well, what about when there is a clear specification? Well, Article 1, Section 1 of the Constitution doesn't say Congress can give up its legislative power to the executive branch as long as it's really clear about doing so. That is not actually constitutional law. So the court hasn't said that yet, but it is the implication of what it has said. And Justice Kavanaugh has basically said that, and I think he's wrong about that. So hopefully the other 5 justices who voted for the major questions doctrine don't also think that, because I think that would be a bad place to go, to say that Congress can give up legislative power as long as it's clear about it. We'll have there's a case pending right now, Consumers Research v. FCC, that'll give us some indication about the answer to that question. I do think it's different from non-delegation. The joke about non-delegation, I think this is Cass Sunstein's joke, which he updates from time to time, that non-delegation had 1 good year and 90 bad years. So the 1 good year being 1935. when the court struck down 2 things under non-delegation and hasn't done so since. So I think a lot of people are excited about major questions because they think, well, the court actually has struck down a whole bunch of things under major questions. This seems to be a actually useful doctrine, unlike non-delegation. But we're fighting like crazy to get the court to recognize the non-delegation doctrine in a way that has real teeth. I co-wrote a chapter for a book at AEI on this question, and we think that the non-delegation doctrine needs to come back. Essentially, what we argued in the piece is that Congress needs to write statutes in a way that creates judicially administrable standards so that judges can tell whether or not the agency is following Congress's instructions or not. And if there isn't enough in the statute to tell whether the agency is following Congress's instructions or not, then it's not clear enough and they don't have the power. So that's where we're trying to go. But there's lots of different theories about how you could strengthen the non-delegation doctrine. That's not the only one.
Thank you.
Yeah. Over here.
Mr. Chairman, thank you for coming. My name is Titus. I go to Scalia Law, and I'm interning with the Liberty Justice Center this summer.
Fantastic.
It's not actually a tariff question, but we were doing other tariff cases.
Yes, right, yes. And Sarah Albrecht was in our offices just a week or 2 ago, your chairman.
No, so actual questions about remedies. We had covered admin law this past spring, and our professor covered all the remedies, options that you get when you are in an administrative case, and it seemed basically most of them are pointless. Like your most common ones would be remand without vacatur, as I understand it. And I was wondering, is NCLA or some other group doing anything to sort of fix the fact that administrative law remedies are toothless? Even if you get the principled win, you still go back and it's just remanded to the agency to do it over, and you get the same results under a different justification.
So, 2 thoughts on that. First of all, I'm teaching Intro to Public Interest Law at Scalia this fall at night. So I think there's more than one of you here who are at Scalia Law right now. But if you're, it's always a fun class. We have a great time in there. So if you're interested in public interest law, check that out. I actually don't believe in remand without vacatur. That's not what the Administrative Procedure Act says. It doesn't say remand without vacatur. It doesn't say the agency gets a do-over. It says you can set aside the rule, which means you set aside the rule. The agency can start over if it wants to, but you don't just give it back to them and say, you missed this one little thing up, so go fix that and then bring it back. That's not actually what the APA says. I agree with your professor that that's what happens in many cases. There's a lot of federal judges out there who don't follow the rules on that, but remand without vacatur is I guess, a sore subject with us, but it's one of the things we're fighting is to make sure that remand without vacatur goes away. That shouldn't be one of the options that judges face. A lot of what we do in our cases, and I think this is true of Liberty Justice Center as well, we're not seeking damages because we're trying to set precedent, and the best way to do that is to get an injunction or to get declaratory relief that says what the government's doing is unlawful. And those can be very powerful remedies. I mean, people are complaining about how powerful injunctive relief is against the president right now, right? Especially in a lot of the immigration cases. So injunctions are real. I mean, that's a real relief. The particular gripe that I have is the district judges have been handing out, preliminary injunctions like candy the last 3 or 4 months, and we had multiple lawsuits against the Biden administration, and we couldn't get a preliminary injunction to save our lives, including against student loans, which were ultimately found to be unconstitutional, including against the nationwide eviction moratorium, which was ultimately found to be unconstitutional. We couldn't get a PI against those things that were actually unlawful. They're handing out PIs against things that are actually okay and lawful. I mean, they tried to enjoin the president from firing Mr. Dellinger, the Office of Special Counsel. The president can absolutely fire him, as the D.C. Circuit said, and Mr. Dellinger didn't even appeal it to the Supreme Court because he knew what was going to happen if he did. So the fact that you have so many judges right now handing out PIs is a problem, but it's not a problem with the remedy. It's a problem with the judges not following the law. There's a lot of conservatives who've been talking about doing away with nationwide injunctions. And let me just say, that's going to be the topic, actually. You're all invited. Victoria will invite all of you. We have something called the Hamburger-Frankfurter debate on the 23rd of July, so Wednesday night. So hopefully there isn't a conflict with anything TFAS is doing. But But that's going to be the subject of that debate, is whether or not nationwide injunctions should be allowed to continue. But think about, now I said we didn't get an injunction in the nationwide eviction moratorium case, but the implication of doing away with nationwide injunctions would be even if we did, it wouldn't matter because every single landlord would have to go out and get their own separate injunction. Or in the case of Mr. Cargill overturning the bump stock ban. So we got it overturned at the U.S. Supreme Court just for him? No. You set aside the rule for the rule is unlawful. Once the court decides that, it's set aside for everybody. And maybe a good way to think about this is if you're talking about a statute that Congress has passed and that the president has signed, that's maybe a different world, right? Because your two branches of the government have already looked at that and decided that it's constitutional, right? Doesn't mean it can't be set aside, but maybe you don't want district judges going around setting aside statutes. But a rule from an administrative agency isn't like that at all. Congress never saw that rule. The president, in all likelihood, never saw that rule. A lot of times the general counsel or the secretary of the department hasn't even seen the rule. There are scads of rules in the Federal Register that a lower level bureaucrat promulgated and put into the Federal Register. If one of those reaches a federal district court and a federal district court says there's no statutory authority for that or it violates the Constitution, why shouldn't that judge have the power as the first sort of constitutionally responsible person to look at it to set that aside, to set that rule aside? If they're wrong, that can get appealed to the next level. But if they're right, like why should this lower level bureaucrat be able to make a rule for the entire country that's unlawful and get it to stick? In the case of bump stocks, get it to stick for 5 years. And, and most of the people, Mr. Cargill had his bump stocks back because we made a deal with the ATF that they'd hold on to them until the end of the litigation. Most people had to either destroy their bump stocks or turn them over to never get them back. And that's all because of a rule that was come up with by an administrative agency, not by Congress. So we need injunctive relief. Other questions? Yeah.
I'll bring it back to tariffs.
Sure.
Thank you so much for being here. I'm from University of New Hampshire. I actually grew up in Arlington, though, so good to be back home.
Yeah.
I have two questions about the tariffs. The first is non-delegation. You had two cases in 1935, and then it basically wasn't mentioned until Gundy a couple years ago.
Yeah.
Have there been any recent cases that kind of signal where the justices are going? And then my second question is, one of the laws that the executive is using to uphold these laws, or the tariffs, excuse me, have to do with a national emergency. So could you talk to a little bit about how the Supreme Court would navigate that and whether or not like a trade deficit is a national emergency or what precedent is on that?
Sure. So first, Gundy is the best case to tell us where people are leading. And in case you think that what was done to Justice Kavanaugh before he was confirmed didn't have an impact, Gundy was heard on the first day of that term, maybe the second day of that term. Justice Kavanaugh had not been seated yet. He didn't hear the case. And as a result, there weren't 5 votes for the non-delegation doctrine restoration in Gundy, which there would have been because Alito didn't provide the 5th vote, but Kavanaugh would have. And how do we know that Kavanaugh would have? Well, he more or less said so in a subsequent case called Paul, believe it or not. So we believe that there are 5 justices on the court right now, including Alito, actually, although Alito's just, if you understand Justice Alito, you know that he's, a criminal case involving sex offenders is not the case in which Justice Alito is going to decide to bring the non-delegation doctrine back. That's just not, he's not going to say, well, it was, we didn't use the non-delegation doctrine against any of these other things, but for sex offenders who have harmed children, yes, absolutely, we should bring it back. He was never going to do that. So, but I think that there are lots of folks trying to get cases up to the Supreme Court, including us, and I do think that when that happens, if the court can not avoid the question, then I think that there are 5 votes on non-delegation. But the court's always going to try to avoid new law if it can decide it on statutory grounds, right? If it can maybe apply the major questions doctrine in the right case and they don't have to get to non-delegation, those sorts of things. In terms of your question about the tariffs and the emergency, so our view is that that the trade deficit is not an emergency. It's been around for decades. So to us, that just means there's a bad fit between the sort of the problem identified and the remedy that the president is identifying. But the real reason that we didn't want to get into that is, as I said before, we're trying to make precedent. And imagine a ruling from a court saying, you're right, that's not an emergency, you win. President loses. Well, the next day the president can declare a new emergency under the same statute and say, well, now it's an emergency, and articulate some other. So it just seems like a bunch of wasted effort. What we need is a statutory ruling that IEPA doesn't allow the president to use tariffs as a remedy. IEPA specifically mentions embargoes. IEPA specifically mentions asset freezes. IEPA specifically mentions all kinds of remedies that would be against the foreign country. That's what all those things have in common, right? An embargo, that's against the foreign country. An asset freeze, that's their assets you're freezing. A tariff is paid by Americans. Like, our client pays the tariff. We had a Revolutionary War in this country about taxation without representation, right? You don't want the executive, whether his name is King George or the King of New York, Donald Trump. You don't want the one person being able to raise taxes on the American people, and that's functionally what's happening under the IEPA case. That's why we felt like we had to get involved, even though we're supporting President Trump on lots of other cases, including the Dellinger case and some of the other cases involving removal power, which we think is pretty extensive for the president. Yeah, in the back.
My name is Marco. I'm also at Scalia Law, from Chicago originally. You mentioned a term that I don't think many of us learned or were aware of before COVID, malinformation.
Yeah.
Can you provide some kind of background on how administrators in the Biden administration, how that term or how that theory kind of took hold, and what's the current status on those kinds of, on using that as a means by which to limit speech?
Yeah. Yeah, so misinformation, disinformation, and malinformation are terms that, boy, if they existed 10 years ago, I don't know that anybody had maybe disinformation, I think people were aware of that, sort of intentionally sharing wrong information in order to maybe propagandize or something like that. I mean, disinformation is an idea that's been around, I think. Misinformation, it's not intentional. It's still sort of false information, but you're not intentionally doing it, so that's that category. And then malinformation is information that may even be true, but they would say that, well, it's incomplete, or there's not adequate context, or even though it's true, we can't trust people with this truth, so we have to keep it from them. That's all under the rubric of malinformation. And where does this come from? I don't know that we did enough work in our cases to sort of figure out the source of it. I can tell you that Rob Flaherty at the White House was a big problem. So we have a case against him, Dressen v. Flaherty, where this is one of the things that the administration cracked down on. So Dressen was, our client, Ms. Dressen, volunteered for the COVID vaccine trials. So she is not an anti-vaxxer. She volunteered for the trials. She was injured as a result of the vaccine during the trials. How do we know this? She was diagnosed as vaccine injured by NIH. So this is not a wackadoodle theory of somebody who says that they were injured. NIH says she was vaccine injured. So what did she do as a result of that? Well, she sat on it for 6 months and didn't say anything, because she was kind of worried about. She knew that it was kind of a rare thing, and she didn't want anybody else to not take the vaccine because of what had happened to her. But she ultimately set up a bunch of online support groups for other vaccine-injured people. You could only be in the group if you were vaccine-injured, and these were like Facebook groups, for example. It's just like a diabetes group or any other kind of support group. I mean, what's working for you to cope, and how are you dealing with this? How's this affecting your family? It was an emotional support network for people who were vaccine injured. The Biden administration shut those down systematically. All of these, and this is private speech, was being systematically shut down by the Biden administration. Ms. Dressen kept trying to set up the groups, and then they would they would not use the word vaccine, or they had all these sort of like strategies that they were trying to use. But a lot of times they couldn't reconstitute the group. I mean, they didn't necessarily know who all the people in the group really were. They were, they had email addresses and what have you, but once the group's shut down, you can't necessarily build the group back up. And so they lost track of a lot of these folks, some of whom were in bad shape in terms of their mental health and so forth. And she's very concerned whether some of those individuals who were denied access to mental health support and a support network and support group might have had something bad happen to them. I know that's not exactly your question, but just the stakes of what happened with the social media censorship, I think, haven't fully been appreciated, partly because the mainstream media was complicit in what happened, and I think they don't want to admit that or report on it. The good news is the current administration has been good on the social media censorship issue. Marco Rubio has rooted it out at the State Department after some early problems where they were, in December, folks at the State Department had moved it from one agency to another agency within the State Department. He's on top of it now. He's rooting that out. Chris Landau, former head of appellate practice at Kirkland & Ellis, is the deputy secretary. He's well aware of this. In fact, he was a moot court judge for one of our moots on this topic. So he understands it really well. So I have confidence there. They've shut down the agency that was doing this at DHS. But we need more, because nothing that they've done so far, I mean, day one executive order from President Trump against social media censorship, not allowing it to happen. But they haven't done things that can't be undone on day one of a new administration. That's what needs to happen from Congress. For starters, if you're going to do this, if you're going to order a social media company to take down somebody's speech, that needs to be a public act, not something that's happening behind the scenes, because there's no way for people to know that they're being censored otherwise. And if you don't know you're being censored, it's hard to sue on that and protect your rights. So, at a minimum, Congress needs to pass something like that. And there's other steps that can be taken. Unfortunately, the administration is not great on free speech on other dimensions. And so, I mean, my boss, Philip Hamburger, is Jewish and is at Columbia University. He's seen what's been going on with the anti-Semitism there on campus. So, he's not the least bit supportive of Columbia's ineptitude in terms of cracking down on anti-Semitism. He and his family have suffered anti-Semitism in the last 2 years that they'd never suffered before. And some of the stories that I've heard from him are really, really not things you want happening in America. These are not good things. But does that mean that the administration can lawfully withhold all funding from Columbia? Not clear you can withhold all funding from Columbia just as a legal matter. That might well be an overreach. So great in the social media censorship, maybe not so great in some of the other areas. Some of the crackdowns on the law firms as well, where they've said, members of these law firms can't come into a federal building. Really? I mean, just because some other partner of the firm did something that the Trump administration didn't like or the Trump campaign didn't like, I mean, that's not actually a valid thing that you can do to crack down on somebody. But these things will get litigated. I think they're going to lose those. We'll see. How are we doing on time? Do we need to wrap up? One more question? Or? Okay. Terrific. Well, thank you very much.
Mr. Chenoweth, you were right from the start. You did successfully make administrative law an exhilarating topic. So thank you so much for being with us. I do have a small token of appreciation for you. But, this was fantastic. We'd like to share the same with you. And to all of our students, thank you again for coming out in good number for our first talk. And yes, please have a safe evening home, and we will see you later this week.